Would you kindly tell the Honorable Court?
Please identify the individual persons that are allowed by your practice to make the entries.
As I've mentioned earlier, the persons who enter the transactions are the new accounts clerk at the time that the transactions were made, and the branch personnel who processes the validation of the deposit is the teller.
But
Your
I'm
Honor.
asking you a simple question. Who are they?
Sir, that happened a few years back, and I wouldn't know, sir, because I was not yet there.
So you do not know them personally.
No, sir.
You were not with them at the time the entry was made.
Yes, sir.
I see. All you know is that they were there because when you examine the documents, there were entries made. Am I right?
Yes, sir.
All right. In accordance with the rule on entries made in the regular course of business, the statements appearing or the entries appearing therein must be made and testified to by the person making the entry. Do you know that?
No,
Or
sir.
you do not know?
I do not know, sir.
And you do not care, therefore, whoever made the entries, whether it was made by Mr. A, Mr. X, or Mr. C.
No, sir.
So you cannot vouch, therefore, for the validity or correctness of the entries made in there. Am I right?
We can, sir, because we have the record.
No, I'm not asking you about the records. The entries made in those documents.
Just answer the question. Can you vouch to the accuracy
Of
and
the
verity of the entries, since you were not there?
Since I was not there.
So you cannot, therefore.
No.
That is my understanding. Now, you therefore cannot tell the Honorable Court that those entries were made at the time of the transaction stated in there. Am I right?
Since I was not there, Your Honor.
You cannot.
No.
You cannot. So you also cannot tell the court when those
What was
entries...
the answer of the witness?
Kindly speak a little louder, Ms. Thompson.
What was your answer?
I cannot, Your Honor.
All right.
I cannot.
Based on the fact that I wasn't there. But if we base it on the records, we will be able to verify.
I'm not asking you about the records. I'm asking you a very simple question.
Okay.
Oh, so you cannot. That's your answer. All right. Would you also be able to tell the court when those entries were actually made by the persons you were alluding to? Because that is a requirement in connection with entries in regular course of business. It must be testified to or known by the person making the entries, the time the entries were made, and therefore he can vouch on the accuracy and correctness of the entries.
Based on the records, sir, we can.
No. Do you know it personally?
Personally, no.
That is
No.
the question.
No, sir, no.
So it is very clear now that all your testimonies given a while ago in connection with the entries appearing there are based only on what you found on the records.
Yes, sir.
They are not
were
based-
based on the records.
They are not based on your personal knowledge.
Yes, sir.
And therefore, that is what is known in the law of evidence as hearsay evidence. Did you understand that? Yes, sir.
Yes, sir.
Thank you. That's all with the witness, Your
All
Honor.
right. Since there is
May I
a
have
cross, you may ask a direct question.
Senator Miriam Defensor Santiago wishes to
The gentle lady
have the
from
floor, Mr.
Iloilo.
President.
Just on this particular point, since I've already gone to the trouble of having this testimony admitted,
Not yet.
just to add to the questions of defense counsel, Ms. Witness, if we just want to recite the necessary fundamental questions, were these records made at or near the time of the acts and events appearing on it? Is that your company procedure?
Yes, Your Honor.
Yes. Was that record kept in the ordinary course of a regularly conducted business activity?
Yes, Your Honor.
Yes. Now, let us read the rules of evidence.
Is this an application of the principle of res geste?
No, we are referring to Section 43, entries in the course of business,
All right.
particularly of
entries in the
Section 32, particularly of Section 37, which begins with a listing of the exceptions to the hearsay rule. Here's one exception, Section 43, entries in the course of business. Entries made at or near the time of the transactions to which they refer by a person deceased or unable to testify who was in a position to know the facts therein stated may be received as prima facie evidence if such person made the entries in his professional capacity or in the performance of duty and in the ordinary or regular course of business or duty. So all you know is that this person must have followed regular entries or regular procedures of entries in the course of business.
Yes,
That's
Your
all
Honor.
you know, because you were not personally present.
Yes, Your
Therefore,
Honor.
it lies with prosecution now to comply with the other requirements of Section 43. You have to show that the entries were made at or near the time of the transactions by a person who is unable to testify. Do you think, Ms. Witness, that the person who personally made the entries might still be able to testify?
Answer the question, please.
I will have to check on that, Your Honor,
You'd
because
have
they
to
might
check.
not be connected with the bank.
That's right. That's what we're thinking. That's what your court is thinking. So at least under Section 43, what you have testified is prima facie evidence unless otherwise disproved. Isn't that so?
Yes, Your Honor. it is-
Counsel for the prosecution, will you take over, please?
Now, counsel for the prosecution, make a
Maybe he-
direct question.
Maybe he will be adopting the examination of the Honorable Senator Judge, Your Honor.
You may, counsel for the defense.
Again, our most generous thank you to the Lady Senator from Iloilo for aiding us and educating us, Mr. President.
But,
I
may we know, Your Honor, the nature of the examination to be made now?
Well,
Because
only-
we are already
only in the-
on redirect. We are through with our cross, Your Honor. So it
Precisely.
must be in the concept of redirect, Your Honor.
Correct.
That's-
Not only in connection, they cannot go beyond the questions
Scope of-
asked during
Correct, Your
the cross-examination.
Thank you, Mr. President. Will you refer again to your record, Ms. Witness, and particularly the certification pertaining to account number 089-121-019-593?
Yes, sir.
Your record that you brought showed it was closed on December 12th, 2011.
Yes, sir.
Improper for redirect, Your
Are
Honor.
you cross-examining?
No,
your
we have
witness?
not cross-examined her on that point, Your Honor.
No, precisely, I'm asking because
I'm sorry,
the
Your Honor.
tendency of the question is a cross-examination.
In the interest of justice, Your Honor, these are questions that the witness may need to testify on, Mr. President.
Tinulungan ka na nga ni Justice.
It was objected to, so what is the pleasure of the gentle lady from
Yes.
Iloilo?
Mr. President, I would like to know, since there are two kinds of rules, on whether a question can be asked on recross. First, you have direct and then cross, and then you have redirect and recross. There is a technical rule that cross can only examine the witness with respect to what has been examined on direct. So there is a limitation. That's why it's very technical. And the same rule should apply on redirect and recross. You can recross examination only on the topics that have been covered by redirect. That is a technical rule. But there is another rule called the open rule, where on cross-examination and on recross examination, the counsel can just ask any kind of question and is not necessarily limited to what has been touched upon in direct or in redirect examination. May I please request a ruling from our presiding officer on whether we adopt the narrow rule or the open rule?
I would adopt the open rule because in cross and recross, you mix up the right of the defense counsel to test the credibility of the witness.
Besides, Your Honor, there is no manifestation whatsoever on the part of the counsel for the prosecution relative to being permitted to ask additional redirect, Your Honor, or direct question. That will disrupt or revolutionize the law on evidence, Your Honor. On direct, after the direct, cross. After the cross, redirect. But that is limited to matters that were taken up in the cross-examination, Your Honor. That's why we pose that objection. And we do not think that is a technicality because it goes deeper into the rights of the accused.
This may well be the time to state the underlying rule in impeachment trial. From what I have read, is that the strict rules of evidence in criminal trial are normally not adopted in impeachment trial. So that's why I've been trying to balance between the strict rules of evidence and a certain degree of liberality. So let us allow the witness, the prosecution, to propound question on his redirect and examine each question whether that is a proper question in redirect.
The question now is whether this is
What was the
this is
question?
entirely a new matter.
What was the last
That's
question?
our perception of the question, Your Honor.
Precisely, I asked the question, the gentleman, whether he's doing a redirect or he's trying to, the tendency of the question is trying to question the competence of his witness.
No, Your Honor. I am on redirect. I am
All right,
asking
proceed.
redirect examination,
Proceed
Your
to
Honor.
make a redirect examination.
All right. Thank you, Mr. President. Ms. Witness, in your certification for account number 089-121-019593, the closing date there appears to be December 12, 2011. Is that correct?
Correct, sir.
All right. There is no entry in your statement. Would your record show if there is a amount closed or closing balance or closing amount for December 12, 2011 for
Your
that
Honor,
particular account?
Your Honor, please, I hope the court will pardon me. This is a very leading question, and this is very
correct.
vital instrument.
Try to reform your question.
Can you tell us, thank you, Mr. President, can you tell us the closing amount as of December 12, 2011 for this particular account?
Almost the same objection, Your Honor. It is more leading now than before. Double.
Let the witness answer. So that, come on. If there is or there is none.
May I repeat that?
Yes, sir.
What is the closing balance for this particular account on December 12, 2011?
And the best evidence will be the document itself, Your Honor. What is involved is the content of the document.
Let the witness answer.
May I explain, Mr. President?
No more. Let the witness answer.
Sir, may I just refer to the previous subpoena? Because I think that was already covered. No.
Can you answer the question? The question is simple. The account was closed on December 12, 2010.
11, Mr. President.
2011. Was there a closing balance at the end of that month?
Sir, right now I do not have it, Your Honor.
What?
So I cannot say how much it is. The closing balance.
The record does not have it.
Right now, yes. I do not have it, Your Honor.
Would your branch have records pertaining to the closing balance for this particular account?
As I've said, Your Honor, all the